This podcast is a product of the Florida Academy of Collaborative Professionals. Nothing in this podcast should be considered legal advice. To find a collaborative professional near you, visit www.collaborativepracticeflorida.com. I'm Catherine Eaton. I'm a member of the Florida Academy of Collaborative Professionals. And on our podcast today, we have Judge Sprysenski. Excuse me, just asked how to say it right, and then
So,
I said
Catherine,
I
we,
messed
we, we
it up.
talked about this
That's
before we
yours.
started recording. My name's Sprysenski. It's brutal. My wife's first name is Brary, so it sounds like library without the lie. So you can imagine her shock and horror on our wedding day that she was Brary Sprysenski. Everyone calls me Judge Spry, and you can call me Chris, please.
Thank you so much, and thank you for the tutorial, even though I blew it. I appreciate it. But I do know, and I will say, that you're a family administrative judge for the 18th Judicial Circuit, and you've been on the bench for 4 years now. And prior to being a judge, you were a collaborative divorce lawyer, and you've handled close to 100 collaborative cases in your prior practice. And you're the former co-president of the Collaborative Family Law Group of Central Florida and an FACP board member, a graduate of the FACP Leadership Academy, and a member of the International Academy of Collaborative Professionals. And you're a board certified marital and family law attorney by the Florida Bar. And that is, and just as what you gave me other info is that you have a hunch that you might be the only judge in Florida that has a full tattoo sleeve, but would like someone to prove him wrong.
I'm pretty sure. I'm pretty sure. I'm not. I haven't talked to Governor DeSantis yet, but I'm pretty sure I am. So.
Okay. I don't. And I'm not a judge, but I'm
Uh,
just chicken. So thank you for joining us today. And I'd like to start our conversation off by asking you, how did you become involved with collaborative law and practicing collaborative family law?
So it's a long story, and I'm going to try to keep it as short as I can. So when I started my practice, I had graduated from law school at a time that was kind of referred to as the lost generation. And I was very, very lucky to be one of my few classmates who, during law school, met a gentleman who kind of changed my life. His name was Dominic Salfi, and he was had a pretty crazy history. He was the youngest, he was the very first state attorney for our 18th Judicial Circuit here in Central Florida back. It would be a circuit court judge, kind of the same role that I am, when he was very, very young. I want to say he was 33, and this would have been the 1970s. But he was this lovely, eccentric guy, and he was so passionate about the law. He would take anything that would come through the door. And most of my practice as an early practitioner was focused on business litigation. Okay. So, for example, folks fighting over a contract, or if there's partners involved in a business and they can't get along, maybe they have a lawsuit to try to end their business or to make them whole with money damages. And those types of cases are so absolutely aggressive. Our judicial system and the way that folks resolve their problems in court, and this includes family law, by the way, is what we call an adversarial process. We literally pit one person against another person, and usually at the end of the day, we have a winner and a loser, right? In the
Yeah.
context of like a business transaction, that would be like money damages, those sorts of things. So, very early on when I was practicing, I was asked to do a divorce. And I had a really good client who wanted me to do his divorce. And I was kind of like, I'm not sure I want to do this. I've heard horror stories about practicing family law. And for some reason, I felt like I had a knack for it. But I just couldn't get over the fact that we were still using this adversarial process to try to keep a family unit intact to some extent, but to end a marriage as gently as possible. Quite frankly, it just doesn't work. And I was introduced to the collaborative process by my friend Elaine Silver, and my first two cases kind of changed my life. What's interesting is my first collaborative case was a complete disaster, and it was partially my fault. My second collaborative case, learning those lessons from that failure, because quite frankly, in my life, I haven't really learned much from my successes. I've learned a whole lot from my failures. From that failure in that first case, I was able to take some lessons into a second case, which was truly a transformative experience for me. If you wanted to hear those details about those cases, we can talk about that if that's interesting to you.
I appreciate that. So you just said that, it's so adversarial and it really is not the right way or the way to go about a divorce. Explain that difference because people who are listening and are about to go through this divorce process, they don't understand what we're trying to explain to them versus with the collaborative process versus a traditional litigation process. Explain how it can be different.
Absolutely, yeah. That's one of my favorite things to talk about. So, I'm going to start with a court-based process, okay? And when I'm typically talking about that, I'm usually talking about all the problems that our court system presents to families. I was in private practice for over a decade practicing family law before I hit the bench. And I was absolutely shocked, and I still am shocked at just how inefficient government is. The greatest gift that I can give to a judge, or as a judge to a family, is finality, right? But our process takes so long and is so expensive. A lot of folks aren't sure what they're signing up for. So I like to use a visual when I'm talking about this, okay? So if you want me as a judge to decide what's best for your family in court, here's how it's going to work. You're going to hire a lawyer, okay? Or you should hire a lawyer because it's very difficult to navigate this process on your own. But I want you to look at this sheet of paper here, okay? And I stole this from my friend Brenda London. This sheet of paper represents everything that you may want to tell me about your family and why it's very important that you want me to decide the case the way you want me to decide it. Well, I have to follow Florida law. I don't have a choice. My job as a judge is to say what the law is, not what the law should be. I know I'm doing my job when I don't like the decisions I make about half the time. Every judge who likes every decision they make is probably a pretty crappy judge because they're probably just doing whatever they want. And so I come home a lot of days very frustrated and upset because I had to follow the statute and did something that, quite frankly, I didn't want to do. So when we look at everything you want to tell me, the law that governs families, Chapter 61 and 742 in Florida, it's only going to let me consider this much information, right? Then we've got these family law rules of procedure. They're the rules that govern how your case is going to navigate through court, and they're very limiting. For example, I won't be able to speak to your children without a prior court order, which requires a special hearing, and quite frankly, it's a very expensive and tedious process. But we have to follow those rules if that's something you want me to do. So those rules mean that I'm going to be limited to hearing this much information. We also have a whole other set of information called the rules of evidence. That is the information that you're going to be presenting to me reliable, right? I can't consider information that's not reliable. And so what that means is I'm only going to be able to consider this much. If you have a family of five, so three kids and you and your spouse, you probably could take up a whole 2 days of telling me what you want to about your family. I have 2,500 cases, Catherine. I don't have time to give you 2 days. I wish I could. So that means the time you're going to get is this. Lawyers are expensive. You might be able to afford this much. And then on the day of your hearing, I'm going to hear objections. It's going to limit me to hearing this much. So at the end of the day, everything that you wanted me to hear about your family, this is literally what I'm going to make my decision on. Court is an inefficient, expensive, long process where I really don't understand what your goals and objectives are because I don't have the time, nor do the law allow me to kind of go behind the curtain to look at that. So that's the judicial process. Collaborative is completely different. And it's the first process that I can think of in a kind of lawyer context where we're focused on solving problems truly custom fit for that unique family. So in the collaborative process, one of the things we focus on are a family's goals. And when I would have consults with clients as a lawyer about this, they'd kind of look at me crazy and they'd say, Chris, I'm getting divorced from my spouse here. This sounds touchy-feely. I don't know if I want to talk about goals, right, with my spouse in the same room. And I would say, well, let's talk about your goals. And Ironically, in that conversation with me, I would always pose the question. So, for example, you just told me one of the goals that you want is to have a close and meaningful involvement in your kids' lives. Do you think your spouse would like the same thing? Yeah, I did. So you have a common goal. You have something in common, right? And my job as that lawyer in helping the goal process is to kind of build that commonality between parties so that they can kind of see, well, maybe we aren't so far apart, right? By focusing on goals, we can also be way more creative, right? Chapter 61 limits what I can do for your family in a divorce context. I can't go outside that structure, okay? But in collaborative, maybe you have a goal for your family that that law doesn't really help. As long as the parties agree, they can be very creative with what's going to occur. I'll give you a perfect example of a collaborative case that I had. I represented a family that owned a big commercial fire sprinkler company here in Central Florida. And the husband, it was kind of his family's business, and he wanted out. He was done with the business. He wanted to do something else. And the wife was kind of done too, but she really wanted to give back to the employees of the company as a part of them kind of winding up. And what they both didn't want to work in the company anymore. And they were also a little light on how are we going to distribute the money that we're going to need coming out of this company in order to make us whole. Well, we retained someone called an allied professional. And the great thing about collaborative is you can kind of bring in people to your collaborative team as you need them. And this person helped us design an employee stock purchase program where the employees of the company could actually buy into the company as owners. That generated capital for the family, and they used that capital to go ahead and essentially buy out the other's portion of the business. So it accomplished their goal to have the employees still involved in the business. It accomplished the husband's goal to leave the business, and it accomplished the wife's goal to receive her equity share of the business. You can't do that in court. You can only do that in a process where you can be creative through the help of lawyers and other third parties.
Explain why you can't do that in court. I mean, you said you're limited to the statutes and you went through, but explain why that wouldn't have happened. What are your restraints as a judge if that family showed up?
Great. So let's say that family showed up in my courtroom, okay? When it comes to how I'm going to divide up the stuff that you own and the money that you owe people, there are four things that I'm limited to doing as a judge. I have to identify the assets and the liabilities that exist in your family structure. I then have to classify those assets or liabilities as marital or non-marital. So, did they come about during the marriage or did they exist before the marriage and a spouse brought them in? Then we're going to go ahead and value those assets so that I can put them on kind of a balance sheet when I'm looking at does one spouse owe another spouse money when we're dividing up the stuff that they own and the money that they owe people. And then finally, I will actually do that division. Okay. So in under Florida law, the husband essentially the shares of the company were in his name. I cannot transfer those shares under Florida law to the wife. I just can't do it. So he would be stuck with the shares, and she would be stuck with getting whatever value she may have tied to those shares. The other thing I absolutely couldn't do is help the family come up with a process to implement that employee stock purchase plan. That is completely outside the realm of our statute. The only tool that I really have as a judge when it comes to dividing up your stuff and the money that you owe people is a cleaver. I just chop stuff up. And so in this particular case, I would say these shares are in the name of the husband. He's going to get them. We're going to need an expert to tell me what the value is. Those experts are super expensive. And by the way, wife's going to need to hire an expert. Husband's going to need to hire an expert, and I can't split the baby. Let's say I don't like either of them, and I say, you know what, it's going to be somewhere in the middle. You can't do that under Florida law. I've got to listen to either wife's expert or husband's expert. I have no discretion to do anything in between. So it is a very risky proposition to come to court, right? Because if one expert's saying something completely different than what you think the value of the business is, and there's no ability to have a conversation about that or to look at other options related to that, I'm stuck with that expert testimony. So, the short answer to your question is statutes are rigid. They have to be followed, and it doesn't let me be creative to address a family's true needs. I have to follow what the statute tells me to do as a judge.
So let me flip the switch a little bit and talk about children's issues. Now we have this presumption that time sharing with the children, it's going to be equal with both parents. So isn't everything simple now? Didn't the Florida statutes make it simple?
That's such a good
That
question, and it makes me kind of chuckle, Catherine. So, um, what we have under the law in Florida is a presumption, and I want to explain to you what that means. The law in the state of Florida now is that there is a presumption that equal time sharing should be occurring between two parents and their children, and that there's a presumption that parents are going to jointly make the important decisions for their kids together. Okay. All that that means, Catherine, is that I start my analysis for the family that those things are going to be equal. But then either party can come into court and say, Judge, this is not in the best interest of a child, and we're going to show you why. That presumption can be overcome by one of those parties saying that thing by just, I want you to think of the scales of justice like you see on the beginning of Law and Order or in Judge Judy's courtroom, okay? Those scales of justice, in order to overcome this presumption under Florida law, one little grain of rice, meaning one little bit of evidence that makes me feel like one parent might be better suited to make decisions for a child, or one parent might have a more conducive household for homework or a child's special needs. It tips that scale in favor of that parent, and I don't need to go ahead and have equal time sharing, or I don't need to have shared parenting. And the problem with this approach is one, it is tremendously expensive because if you're saying, hey, Judge, I want to show you I can meet my burden and overcome this presumption, we're going to have a whole trial. And I can tell you it's very rare that folks come into court in that context where they spent a year and a half in court because court's so inefficient, it takes so long to get the documents that you need and all that jazz. Where they haven't spent on their own individual lawyer each 30,000, 35,000. If I got a family making maybe combined $250,000 a year, you could be looking at a fifth of their gross revenue spent on lawyers' fees, which is atrocious, right? Um, the other thing too is under 6113, the statute that I have to look at and where this presumption lies. I only can consider factors that are enumerated by our legislature in making that determination. So, one factor, for example, is the geographic viability of the parenting plan. Does it make sense that mom have most of the time, or does a family have equal time if they live, for example, an hour apart? How are they going to transport a child to school when they live an hour apart and they might live an hour from the child's school? So it becomes this very difficult analysis. And unfortunately, in meeting these statutory factors, most families focus on negative stuff. They focus on, well, this parent's not doing the homework, and this parent is not available as much as I am, right? And it just sets the family up for a basis of co-parenting based on negative testimony. Um, uh, that's a horrible way to look at that problem. In collaborative, we look at it completely differently. We rarely open the statute at all to look at those statutory factors because we're starting with goals. We want to understand what the family would like to see for their children, but more importantly, why. Because the why usually drives us to do something called option building. So in collaborative, if you're not familiar with the process, we meet in a team environment. So you're going to have both spouses, and then you're going to have both their lawyers. You're also typically in Florida going to have a neutral mental health professional. We call that person a facilitator, and you're going to have a neutral financial professional. I absolutely love this structure for children, and here's why. Um, I am 47 years old. I don't have children. I got two wonderful fur babies, but I know very little about child development, right? Luckily, as judges, they kind of teach us a little bit of this stuff. But again, under the statute, I really don't get to consider a lot of this stuff. And quite frankly, most lawyers don't know how to present it to me. So what I can do in collaborative is I can take the spouses without their lawyers, by the way, and they can sit and have a conversation with that neutral mental health professional. And through that conversation, that neutral mental health professional can use that expertise that they have to educate the parties about what types of options might be best for their unique kids. For example, let's say we've got a family that has very young kids. The studies show that for children between the ages of 0 and 4, that those children are forming attachment bonds with their parents. And the more that you disrupt their ability to see a parent continuously, the less strong attachment bond that child's going to have with that parent. As a judge, I don't get to look at attachment bonds under Florida Statute 61. And so I very rarely see lawyers talking to me about the importance of that in looking at a parenting plan. When that family works with a neutral mental health professional and collaborative, they're going to have a conversation like that. The mental health professional is probably going to educate them that, for a 0 to 4 year old, we need to look at a highly rotating parenting schedule where that child is getting as much face time with both of you as possible during the week so that when they pass that 4 year old threshold, they have these strong attachment bonds with you. They trust you. They love you. So then they can start developing their own personality, which what happens started at age 5 or so. They start building friendships. They start building personality. So all this analysis about what kids need from a mental health perspective, a developmental perspective, it is very rare that you're going to have those conversations in court. So that's just one dramatic difference in kids' issues as to how we're going to handle that in collaborative and how are they going to handle that in litigation. The mental health professionals typically going to come up with the outline of what a parenting plan is going to look at based on that educational discussion with the parties, and based on kind of the goals that we've all talked about at the beginning of the case. And so usually the lawyers, when it comes to children's issues, are usually helping the parties with difficult conversations as to one or two unique issues. For example, long moves for work are typically a pretty hard issue to discuss. But we're more than likely just making sure that we're doing what we are trained to do, which is to develop a document that provides all the detail the family needs based on that conversation with the mental health professional. I hope that answered your question.
That did answer my question. So thank you for that. So tell me what, and it's a little repeat of what you've been saying, but tell me now that you're on the bench and you're a judge and you practice collaborative, what do you think the gap is? Why do you think people don't know about collaborative or aren't as much as they do about what goes on at the bench? Where's the gap?
I think that's such a good question. So, um, one thing I hear a lot is from lawyers. So we're going to start with lawyers and we're going to talk to other folks. I hear from lawyers that, I get nervous about doing a collaborative process because um, I feel like we don't talk about the law. And as a lawyer, I have a responsibility to educate my clients about the law and advocate for my clients about the law. And I tell those lawyers, well, I can tell you if we're not talking about the law at all in a collaborative case, that's a problem, okay? Because the law does play an important part in a collaborative case. The law, in my mind, in collaborative, sets kind of the end posts of our conversation about how do we develop goals for a family. Okay. So I'm going to give you an example. I think the hardest conversation to have in a collaborative case is about how a spouse who might be making more money than another spouse is going to help that spouse who's not making as much money transition from their married life to their single life. We call that under Florida law alimony, but I would never use that word in a collaborative case when talking about it because there's a lot of emotion related to this concept. This payor spouse usually has a lot of emotion about, you mean I have to pay my spouse after we're divorced, even though, I've supported my family for the entire time that we've been there. So we talk about it in a different way. But if we don't talk about what Florida law is on it, sometimes we haven't set the client's expectations appropriately in the collaborative process. In Florida now, we have a calculation that governs what spousal support looks like for a family. And I won't get into the details of the calculation, but we have a calculation. And if we don't talk about the fact that there is this calculation, we're doing our team members a disservice because it may result in a participant having an unrealistic expectation of what they could receive from the process. So, for example, if that formula under Florida law says that at most a spouse could receive about $2,000 a month from the other spouse in support, if they don't know that and the other spouse thinks that they absolutely need and can't survive on anything more than $5,000, we're going to be doing that family a disservice because we're going to keep having a conversation about something that would never happen in court, right? So that's one aspect of why the law is so important and collaborative. So we do talk about the law and collaborative. But on the flip side of that, now that I'm a collaborative professional sitting on the bench, um, it is very hard for me to do the same type of option building with a family that I was able to do as a lawyer because I'm typically seeing a family at about 75% into their litigation process. I don't get to see families all the time right at the beginning. And by that time, who knows what's happened with the case, right? We don't know whether the lawyers have done a good job of making sure the client's expectations have been set. We don't know whether there's been dramatic fights about kids' issues or money issues that has resulted in bad behavior occurring in the case. These folks aren't checking in with a normal mental health professional or something like that to try to get through roadblocks or unique issues. It could be off the rails. And at that time, all I can do as a judge is take the facts and apply the law. That's all I get to do. I don't get to come up with, for example, creative options like that employee stock purchase plan. And so a lot of times I'm very frustrated from the bench because I want to have a conversation with a family about, hey, have you thought about this? Have you thought about that? But that's not my job as a judge. My job as a judge is to basically call balls and strikes and to apply the evidence code to the facts that I'm hearing in front of me. So I'll say, having done so much collaborative when I took the bench, becoming a judge was not an easy decision for me. I still struggle with it quite a bit. But at the end of the day, I can honestly say the reason why I made the jump was to hopefully maybe bring collaborative into the courtroom. And I don't think it's going to happen anytime in the next year or 2 years, but in the 1980s and 1990s, this concept of mediation was a foreign concept in most parts of the country. And if for folks watching that don't know what mediation is a confidential conversations that a lawyer and their client and the other lawyer and their client have with a neutral person, and that neutral person essentially helps negotiate a settlement. Okay, but that most of our cases, 90% of our cases in court, kind of settle in mediation, and it took a while for that to get traction, and now it's kind of the status quo. So now that I've got my sea legs, wearing a funny robe every day and doing this job, one of my big goals is to try to start a program where we're offering collaborative type services through our court system to help scale the cost of collaborative and to show families that this is indeed another option.
Thank you. And thank you for making that goal. And I think that this podcast will help to educate people out there about collaborative. So thank you
Cool.
for being a guest today. And I hope to have you back again soon.
It was a pleasure, Catherine. I really appreciate it. So, and I hopefully you didn't hear my dog snoring in the background, but
No snoring.
okay. Thanks so much. Have a great day, Catherine.